This is douglAR politics, yo. douglAR politics. Listen, douglAR politics, yeah. douglAR politics. This is douglAR politics, yeah. douglAR politics. This is douglAR politics. douglAR politics. This is douglAR politics, yo. douglAR politics.
Yes, it is I, Kiel Tacklalsingh. I'm holding for my good friend and political brother, Mr. Arnold Roberts. Fortunately, he could not be here tonight, so I will be trying to take the fight forward and explain a few things. We will be joined by MP Saddam Hosein tonight, I believe on Zoom or virtual, Archie?
Yeah.
Virtual, right. We'll be joined by MP Saddam on Zoom, and hopefully we could get into some of these topics. Well, I think the main issue which people have been wondering about tonight, actually, and I think for the rest of the week, would be this disappearing file and reappearing file. I believe it was Senator Mark who spoke about Mumford the magician today or yesterday in the Senate. Whether it be Mumford the magician, abracadabra, Harry Potter, Voldemort, really doesn't matter whether or not a file appeared or reappeared. At the end of the day, what we do know is that the Attorney General's office is in disrepute. It has shown itself to be an incompetent institution, and that could only be as a result of poor leadership in the Attorney General's office and also poor leadership of the country under the stewardship of the Prime Minister. I don't know how else we could explain that. As far as I understand leadership, the buck stops with the leader. And therefore, if these types of mishaps which will cost the population $20 million odd, by the time it's paid you might have interest, you have to put on cost on top of that, you're looking in excess of $20 million that taxpayers will now have to fork out to these gentlemen who were acquitted of a crime because of pure incompetence by the state, negligence. And what is even worse is that the Attorney General decided that he would come and make a song and dance sleight of hand in keeping with the magical theme of his office. Came and he made a sleight of hand and a parade and spoke about files appearing and disappearing and that things were sinister and all sorts of nonsense, absolute nonsense, when the truth and in fact is it was pure unadulterated incompetence that led to the missing file or the inability to defend the action. There was absolutely no way, in my respectful view, no way on earth that the Attorney General could not have known about this matter and could not have known what was happening to it. And whether that spanned both Mr. Al-Rawi and Mr. Amor, that is, I suppose, may come out in the investigation. But what we do know is that the chronology started under Mr. Al-Rawi and went on to Mr. Amor. So I really can't see how either of them could exculpate or take themselves out of this scenario. It really can't work. And I will go through, and maybe MP Saddam Hosein will also assist me in going through all of the layers of protection that are inbuilt in our legal system and legal rules to protect defendants like the state of Trinidad and Tobago, which is represented by the AG's office, from ensuring that this madness does not take place. It is really, really unfortunate and unacceptable. You okay there technically? Yeah, good. Right. So, let's deal with this one by one. You have a claim that is filed in court. It is served on a defendant. When it is served on a defendant, you have a little endorsement. We know that happened. When a claim is filed, a defendant must put in something called an appearance and it must put in something called a defense. We know that the Attorney General failed to do that. Those were the first two protections, being served with the document so that you could respond. All right, let's say he didn't get that. What then happens is that the Attorney General must then file another document in court called a notice of application to get default judgment. That document, notice of application to acquire default judgment, must also be served on the Attorney General's office. And it was. So did that document go missing too? We won't know. Or hopefully we do find out. But you see why it's unbelievable. So whereas the Attorney General talks about some file disappearing which contained the claim, the statement of case, the claim, what about this notice of application? That is a separate document that was filed. Let's move on. Notice of application, file and serve. Okay, you missed that. The next thing that happens is that the court sends a notice of a date of hearing to you, the Attorney General, to attend court, or by email to attend a virtual link. You also misplaced that. That's the third thing. So you misplaced that. Okay. What about the actual hearing for court? All court hearings are listed. It's public. Reporters often check to see what matters are going on so that they could follow and bring news about cases. Don't we have somebody in the Attorney General's office monitoring the cases that are listed and trying to detect whether the Attorney General has a claim in court? So that's the fourth protection. Missed again. You could have gone before the judge and said, Judge, we didn't get these documents. We now want to put in a defense. You file an affidavit. You explain that. Also missed. 5 protections. Then, when the judge granted the judgment, the order saying that the Attorney General and the people of Trinidad and Tobago are now liable for this money, that judgment, that document, has to also be served in the Attorney General's office. 6th protection. And all of this before a cent has to be paid by the taxpayers, or all of this before we become liable to pay $20 million. And all of this, at each step, the Attorney General's office and the Attorney General could have intervened to stop this travesty of justice. But it did not do it. Chose not to do it. The Attorney General himself, well, either one, well, I don't know about Mr. Ravi, but at least Mr. Moore could have put on his robes and go down there and ask the judge, look, Judge, I need time. All lawyers have to do it at some point. He didn't do it. So the judgment, liability, because I want you to understand there are 2 phases. There is liability, where you have a trial on liability or a determination on liability, i.e. otherwise you're found guilty of something or you are found liable to pay something. When that over, it moves into something called a quantum phase, meaning to assess how much money you have to pay. So we finish with liability, about 6 protections. When that default judgment is served on you, you should have had notice that it's moving to quantum. You could have applied under the rules of court to set aside that judgment. You failed to do that. Next protection, we move into assessment of damages now. The court is now going before a different judge, someone called a master, to assess how much money we have to pay because these men spend X amount of time in prison, were subjected to poor prison conditions, all of those things. The court would send a notice to the Attorney General's office. You have to attend court. At that point, you should have seen the notice and asked, well, what matter is this? What is this about? Let me go and try to find out and get the file. And we saw, according to the Attorney General's press conference, he was able to get the file in 1 day. So when he got that notice, he didn't have the file. You didn't know. You didn't think, hey, these are the men who are freed of the killing of Ms. Vindra Naipal Kuhlman. The society isn't going to take this easy. This could be very liable. This could cause us a lot of liability. Taxpayers would have a heavy burden because of this negligence. You didn't think at that point you should have intervened, Mr. Attorney General, Attorneys General, either one of you? No? Okay. Court is then called, and what we do know is that at that point, lawyers attended. At the assessment phase, lawyers attended, did nothing. In fact, as the records and judgments show, they participated in assessing how much money we had to pay without a care in the world for the fact that we have to pay this money. And that demonstrates beyond a reasonable doubt, it demonstrates beyond any doubt, that the Attorney General's office was fully aware of what was going on in this matter and fully aware that the taxpayers may be subject to pay a large sum of money to these former accused. And then you had the judgment entered where we have to pay $20 million. Even at that phase, no application to set aside. And what we do see is that certain recommendations were made by the attorneys to the judge in the assessment phase to pay sums of money as opposed to the sums of money being claimed. From my experience as an attorney and conversing with attorneys from the Attorney General's office, the only way those attorneys would do that is if they have instructions from the Attorney General himself. So what is taking place? Why does it matter whether a file appeared and reappeared, disappeared and reappeared again? That has nothing, that is distraction. I want everybody to understand that. All of this nonsense about file disappearing, reappearing, was never lost. That is absolute nonsense. A file is not a folder anymore. A file consists of several documents, electronic documents. What we call a file is not like in them, folio and that sort of thing. That doesn't exist anymore in court. You have electronic files. Some are paper, some electronic, sorry. And this is what I can't understand, and we must move away. Don't buy this nonsense about file appearing and disappearing. That has nothing to do with it. What we have to focus on is the fact that the leadership in the Attorney General's office and leadership of the country is sorely lacking. And that has played itself out and is amply demonstrated in the nonsense that took place in this matter. Archie, is the MP on?
No.
Okay.
Oh. Not yet.
Not yet, all right.
I'll let you know when
Yeah, that's fine. That would be a good time to bring him in, because I'm sure he would have, with that run up, we could have delivered some fast bowling. Right. So all of that nonsense, I want people to understand very carefully, having followed the chronology, that the law, the rules of court, the procedures, all are put in place to protect a defendant from having an unjust or unfair judgment entered against you. Think about it. Somebody sues you today. You think they could just go and pick up a judgment in the court without you getting a chance to defend, or you getting sufficient notice, you being able to take legal advice, and you appearing in court? And the rules allow, even if you miss a step or a second step, the rules still allow you to come and explain to the court what happened, and you can ask the court for an opportunity to defend or set aside a judgment. And the tests are very simple. We don't want to get too technical, but the established test in law is that you must act promptly and you must have an arguable defense. A defense with a realistic prospect of success. That's simple law.
Kyle, what about those who say that the conduct of the state lawyers needs to be scrutinized here, and perhaps the state lawyers are to blame in this case?
Absolute nonsense in my estimation. I'm sorry. I can't agree with that, and I'll tell you why. Two reasons. One, the state attorneys, in my experience, highly competent, well-trained, and they defend the state's interests with passion and vigor. I lost a case just 3 days ago. I thought I had it won, and then the state lawyers pull out some arguments. I will now have to appeal, right? I'm not taking my loss, right? But the state's lawyers are formidable. They know what they're doing. In fact, so formidable that one of the state lawyers is now a judge. So she was assessed to be competent enough to be a high court judge. So all of this about state lawyer. The state lawyers don't act independently. It's not like a chambers. It's more like a firm. And let me explain the difference. A chambers is where a bunch of lawyers share office, space, but everybody has their own independent practice. I could do family, my colleague could do this, whatever. We don't share fees, that kind of thing. That's how a chambers works. A firm, you have a head, and you have lawyers working for the head. The Attorney General's office is more like a firm. You have the Attorney General, you have the Solicitor General, you have attorneys there who are part of the public service. They're given ranks like legal officer 1 to 3, I think it is. And state council 1 to 3. And that is where you have to act in accordance with the instructions of the Attorney General and the Solicitor General. That's how it works. So no state lawyers, they're acting rogue or independently. And even if there was some negligence, there was sufficient time to pick it up and solve this issue. And even if there was negligence, the law says that yes, while attorney error is not the only reason, or is not a sufficient reason to set aside a judgment, it says that attorney error is a matter you can consider. So even if the Attorney General went to court with another attorney and said, well, the attorneys were misinstructed or misguided or acted on their own in doing this, but this is the real position, that is something the court could take into account. The fact is that I am sure they are not going to do that, because there are no grounds to blame the attorneys in this matter. I can't see that. I would have to be shown something in paper, I would have to be shown something more substantive to believe that it is any state attorney that is causing that. We have to be realistic in this country, and we need to hold leaders to account. When organizations fail, it's the leader. You have to look at the leader. You have to look at the Attorney General. The Attorney General is liable for this loss. $20 million of our taxpayers' money that could be going to roads, that could be going to healthcare, that could be going to education. They've cut scholarships. How much scholarships $20 million could have granted, Archie? Could have financed in 5 years? Huh? $20 million. How much scholarships that could have been? How much students could have accessed GATE with $20 million? How much? How much school book lists we could have filled with $20 million? How much box lunches? How much of these things that are so critical? Archie's a technology man. How much iPads or devices we could have given to children to enhance their learning? How much we could have done with $20 million?
All. And those to come in.
Yeah. And now the state would have to take that money, give it to 9 men. So 9 individuals have benefited. And let me be very plain about something. You have a right to sue the state if you win your case. But everybody knows that malicious prosecution is a high bar. Let me put it like this. Simply because you win a case in court, if you are charged by a policeman or arrested and charged, simply because you win your case does not entitle you to file a malicious prosecution lawsuit. Or you can file it, but it doesn't automatically mean you win your lawsuit. You have to satisfy a court that the police, to put it simply, acted with malice. And that's a high bar. You must demonstrate that the police acted without any reasonable cause to arrest you or charge you, or did not have an honest belief, which is something difficult. Cases are lost because the police had somebody sign a statement saying, I saw you shoot, or I saw you rob. And that is sufficient for police to charge you. You can't win a malicious prosecution suit with that unless the police had real reasonable grounds. Unless you had grounds to show that the police didn't believe the witness, but still charge you anyway, which is difficult to prove. So what we do know is that the state that retained 3 senior counsel, I believe it was, for the criminal prosecution in this matter, and 3 senior counsel would not have allowed a case to go forward in a criminal court without some reasonable grounds. Without some reasonable grounds. 3 senior counsel looked at those files and said, go ahead. We'll prosecute this case, because the duty of a prosecutor in law is a very high one. The law says that a prosecutor is a minister of justice. So he can't continue a prosecution if he knows he has nothing. So we have to assume that the prosecutors had something, and therefore the state could have put up a defense. But they did not put up a defense, and that is solely because of poor leadership, poor management in the Attorney General's office. I saw a post, I think it was by Nafiza Mohammed, and I think that, actually I don't know if you could get it on Facebook. Nafiza Mohammed, you might have to, you have it on See if somebody could send it to Archie on that. Because, and I want to say that I thought that she really, she brought out some issues there that I didn't think about. But it seemed to me to be something on point. Oh, the MP is on? MP, are you there?
Good night, Kyle.
You're looking like in Parliament. Oh no, this is a okay. MP, you there?
Yeah, can you hear me clearly? Hello?
Yeah, MP, I hear you now. You there?
Okay, good. Yeah, I'm here.
Right, good. So I was just discussing with the listeners and viewers the entire imbroglio in the Attorney General's office. And on one of the first points, and you let me know if you agree, and you would know about the process of getting a default judgment and trying to set aside a judgment. There are sufficient protections in the law, in the rules of court, in service of documents that would allow somebody like the state who has had a judgment entered against them to approach the court and set it aside. And it also, those protections would have ensured that all of this missing file thing is absolute, is very difficult to believe. I don't know, what are your thoughts on that?
So, good night, firstly, Kyle, and to the viewers of douglAR Politics. I want to agree with you 100% that when there was a change of the rules in terms of the CPR, there was sufficient protections being built within the CPR in order for protection for defendants and claimants within the rules, specifically for default judgments. You would even see, Kyle, that the state is treated differently even when it comes to the time to file a defense. Let's start from that point. Yes. An ordinary private citizen has 28 days. The state has 42 days. So the rule itself contemplated that the state may need some more time because of, the workload of the state. So let's start basic there, that they have more time to file
the amount of litigation that would probably come against the state. They need a little more time. Yeah.
And the rules contemplated that. The rules also contemplated that if a default judgment is entered against you, over the counter judgment, there are rules in place to set aside that default judgment. Now, one wonders why an entire investigation is being launched into this matter, but they have not yet triggered the rule to set aside a default judgment. Let's start with that point.
And I agree with you, and I was also saying that even if, according to their explanation, let's break it down step by step, even to their explanation, a claim is served on them, claim form statement of case. Let's say, all right, that went missing. We don't know how it went missing. In order to get the default judgment, you have to make an application for default judgment and serve it on the Attorney General's office.
All right.
So did that document go missing too?
Based on the Sunday Express, there was an entire article with a chronology of who was served, the time it was served, the date it was served. When you read that article, it was very comprehensive in terms of the chronology. The state was always aware of each step of the time in which the matter was progressing. From the time the claim was served, from the time the application for default judgment was made, the state was always made aware. In fact, I can't understand how you can go to court without a file, without instructions, and make submissions. Now, that is something that's a mystery. I'm surprised they still have the file. By now, I thought the file would have gone missing again. In one minute, we're hearing that an appearance was filed in the matter. Next minute, we're hearing an appearance is not filed. So this entire situation is bizarre. But Kyle, I want to let you know something. This matter stemmed from the criminal prosecution of these 12 accused in the Vindran Ipol case. I was working in Ms. Sita Hall's senior counsel's chamber at that time. And you would understand, Kyle, that was not a file, Those were boxes and boxes and boxes of evidence, which would have formed the basis for the state's defense. So you're telling me these accused men sued the state for malicious prosecution, and you didn't have the courtesy to even call the DPP's office to get a copy of the preliminary inquiry, of the trial notes, of the appeal notes in this particular matter to properly frame a defense to protect the public space. So, what the Attorney General is telling us is that there was some level of gross negligence somewhere along the line. Because you can't tell me that you're going to court on a matter, no file, no defense, and up until this date, we didn't hear an application being filed to set aside the default judgment.
But as you raise gross negligence, I've heard, and someone asked a minute ago, that there's some blame trying to be put on the state attorneys. Now, my experience with state attorneys, most of them, if not all, are competent. But what I know is that because of, I would suppose, a little lethargy in the state office, all of them understand what a default judgment is. And I think all of them understand how to swear an affidavit to set it aside. That's a normal thing with the state. They know how to do it. So I can't understand how state attorneys would simply look at this default judgment and allow it to go. In my view, from what I have seen, I refuse to believe that. And I think either Mr. Al-Rawi or Mr. Amor had to be aware of this scenario that was unfolding in the court. And I say that because it is my experience that state attorneys, anytime you're negotiating with Saddam, maybe you could tell me if you do it different, but anytime you negotiate with the state attorneys and you're back and forth on a figure that you want to settle or cost, the first thing they tell you is they need to get instructions from the AG.
Now, that's an interesting point you raise, because at every point in time, you need the instructions of the Attorney General in order to do anything in court. Especially, I had experience at the DPP's office. I think you were at the AG's office for some time. But even at the DPP's office, before counsel can take a position in court, we need to get the approval of the DPP. And I believe the same occurs with respect to the AG's office.
Yes.
Anytime counsel appears in any matter, counsel must be acting upon the authority of the Attorney General.
But
Any
attorney has to act with instructions. No attorney,
Correct.
All attorneys must act with instructions. The attorneys at the private bar have a little more latitude when you're representing your private clients, because you would have taken instructions en masse. But certainly if you're acting for an Attorney General, I would think before you move to any next step or made any major decision, the Attorney General or the Solicitor General in some cases, but the Attorney General had to be made aware of it and had to provide you with some kind of instruction.
Correct. Yeah, and you see, the position now is that the public has to pay $20 million worth of damages, which could have been saved. I saw the Attorney General during his press conference quoting extensively from the appeal, saying that the state has a good defense, that they may, that if this matter may have been properly tried before the High Court judge, there might have been a different outcome. But whose fault is that? That is the fault of the Attorney General's office. And they will the modus operandi of this PNM government is that they will blame everybody else.
Yeah.
They'll blame everybody. They'll blame the State Council, they'll blame the Solicitor General, they'll blame everyone. But it has been.
They want to blame a judge now. So I
They
don't
blame
know
the judge.
I don't know how far. I don't know how far this is going to take them in blaming persons. I think what taxpayers and I'm sure your constituents are more interested in is how did this happen, and what are you going to do to ensure that this never happens again? And of course, well, if there is anything that we could do, which quite frankly I don't think now, because of how the Attorney General is acting, appointed investigators, etc. I don't think there's anything they could do to set aside the default judgment at this point.
Well, Kyle, my constituents are asking whether or not Faris is going to take the rent money to cover this judgment. He might still have a surplus of $3 million if he still if he uses that money. But on a similar point, in the last budget debate, I raised the matter of Ashton Ford, Andrea Chambers Wilson, Elvin Edwards against the Attorney General. And that was a matter in which they would have filed a claim against the Attorney General for damages for unfair dismissal. We were in government at the time that matter was filed, during the 2010 to 2015 period. And that case was managed through our Attorney General at the time. And when the time came for filing of witness statements, we had lost government by then. So Faris Al-Rawi was the Attorney General at that point in time. And Kyle, do you know that they did not file witness statements in that matter? While we were there, we filed the defense, we filed our pleadings to defend the matter. When the time came for witness statements, the state did not file the witness statements. On top of that, when the matter came up for trial, they did not even appear on the date of the trial. So you can't tell me that the state was always aware of when directions were given in the matter. You take no steps to file the evidence. You didn't show up for the trial. And because of that, the claimants, that's Ashton Ford, PNM General Secretary, former PNM General Secretary, and Elvin Edwards, former PNM Aruba Mayor, would have walked away in court with $2.65 million.
Yeah.
$2.65 million.
I mean,
It's absolutely ridiculous.
It sounds from what you're saying, it sounds a bit contrived. I mean, we can't say for certainty, but quite frankly, from what you're saying, it sounds very contrived to me. It is very odd that the machinery of the state, having filed a defense, and you can't file a defense without instructions, and therefore if you had instructions to file a defense, you certainly had instructions to put in a witness statement, and as lawyers know, even if the witness is uncooperative or unwilling, you can file a witness summons to compel the witness to come to court, and you file a witness summary of what he has to say, so that the court is aware of what he has to say. And at least you would appear, and on your pleadings, you could still cross-examine if necessary.
Correct.
Yeah, and you could have broken down damages. In fact, you could have made some lawyers, if you know your witness may not come, you make a no case, or you elect something in civil law. You could call elect. You elect. You decide you won't put in your defense witnesses, but you will stand or fall on the evidence of the claimant. Those are tactics that lawyers know to deal with these kind of situations when they occur. But as you said, if no lawyer showed up, then we were unprotected. The taxpayer was unprotected. The state was unprotected, and our treasury and coffers were unprotected under this PNM government.
And then we have to look at the history of this government since 2015. You would remember the Malcolm Jones matter, where the Privy Council had a lot to say about political interference in that particular matter in terms of the withdrawal. Yes. You had the matter involving the former directors of ETEC, where the government would have sued for about to recover $35 million worth of taxpayers' money, and again that matter was withdrawn. So you have seen,
because it's so strange, not to cut you off, it's so strange because you look at the vigor in the defense of those matters, but when it comes to any case that Anna Ram Logan files, or any other lawyer that they like to label UNC lawyers, including myself sometimes, as soon as they lose, appeal, we're going to appeal, and just by virtue of them saying it is appeal, is almost as if they say they win, that the judgment doesn't count, right? So when you compare the vigor by which those judgments are dealt with, and the vigor in which those that you mentioned are dealt with, you really understand what is going on in this country.
Well, we saw the outcome of the appeal, I think, last week with respect to the Miami matter. Well, when they believed that they were going to win that matter.
That's a nice segue. That's a nice segue into that issue now. I mean, the Attorney General, I think, and Saddam, we spoke about this, is extremely discredited. I don't know what adjective to use that could be worse than extremely, but he's totally discredited now in the eyes of the population, I think, on two accounts. One, ethically, you attended meetings and gave evidence against your former client. Well, not evidence, but you gave instructions or took in an instruction session with lawyers who are acting against your former client, which is something attorneys don't ever do. We know that from our ethics. But what is even worse is that you misrepresented on an affidavit. You made serious misrepresentations on an affidavit to cover up your unethical behavior, and that can't be right. Any other Attorney General anywhere in the Commonwealth would be forced out of office.
Yes. And that's a very good point, because this matter is going to be totally mismanaged, and I'll tell you something. It started at Amo, and on Monday night I raised another issue, whether or not another senior cabinet member was involved in that Piaco matter, who is now currently involved in the management of the Miami matter. as acting for the government,
Right.
acting for the defendant in 2004, and now acting on the government in 2023.
Yes.
And that raises serious concerns. I raised issues with respect to a particular state witness and whether or not that person collected lucrative briefs and whether or not that person was paid to give evidence. I will say more on that particular matter when the time comes. But we have to keep our eye on this matter because this is costing the taxpayers a lot of money. During the budgeting exercise, I had asked the Attorney General, what is the cost to the taxpayers since this matter has been filed? Kyle, he reported that there was about $29.3 million spent so far in this Miami matter, and we have not recovered a single cent from this matter.
Do we know how much money was spent to just deal with Amor's misstep, the
With the appeal?
conflict of interest issue, and then the appeal? Because I'm sure that has to be some serious money having to go to the Court of Appeal. Do we know the exact figure, or you just have a conglomerate figure?
So the $29.3 million was up until October of last year. I will file another question in Parliament to ask how much was spent to
Defend
hire the new crew.
this recusal application or this disqualification application, and then the
and
money
the
and the appeal, because that certainly Mr. Amor has to be liable for that, whether it comes out of his own pocket or he has to answer politically for it. But that is
Because
what his European hotel room foyer, his escapade has cost us. Unfortunately,
I don't know
you
if-
hate to put it as light as that, but
I don't know if he was
that
under the
misstep
influence.
is costing taxpayers a lot of money on top of this $20 million.
And I don't know if Mr. Amor was under the I'm asking, I don't know if he was under any influence of any drug or any other thing while he signed that affidavit in a European hotel room.
Yeah,
But
yeah.
clearly, a person who had just received silk to indicate that he was a junior counsel note taker in a matter. I mean, that you cannot find anything worse than that in terms of a sitting attorney general lying on affidavit.
And you know, and that's the thing, yes, senior counsel, forgetting senior counsel, that is almost impossible to believe. But more
Correct.
importantly, for you to say all you did was take notes when you cross-examined or made submissions on evidence in a matter, according to the
Written
transcript.
and oral submissions.
Yeah, made submissions on evidence. I believe, yes, it was submissions on evidence in a matter. You made submissions in one of the biggest court cases in the history of Trinidad and Tobago. And you forgot, and you want to tell us, even if you forgot, you want to tell us all you did was take notes? No, I'm sorry. No way I could believe that.
So, Kyle, I know you were very instrumental with the Law Association on this matter. And you would have filed a particular motion summoning the Law Association to deal with this matter. And we heard the arguments that, well, Mr. Amor made an error, but his career precedes him. He's a good boy, basically, right? He lied, but he's a good boy. And if you remember, Kyle, the Law Association had sent a media release around that time saying that they're going to investigate the matter before the motion was heard,
Yes.
saying that they need to look at all of the facts of the matter. Well, basically, there are no facts to look at again.
Case
The
done.
only fact is Amor was disqualified by the first instance judge, and the appeal upheld the first instance judge decision. So
Yes.
there's nothing to investigate.
Yes.
The Law Association must now break their silence.
Well, I agree with you fully. The Law Association now has a duty to comment on this matter, specifically because I would say that this was the subject of a no confidence motion previously. But particularly where some of the excuses we heard, or some of the, let's not say excuses, some of the justifications or arguments by the lawyers who were supporting Mr. Amor were that, look, the matter is still in appeal and it's premature. I believe that came out from at least two lawyers there, one senior counsel and one senior junior. And then you had all of the other arguments which made no sense to me. But the point is, the Law Association, I agree with you, they have an obligation to comment on this issue. I'm not going to say, I know what I would say if I were the president of the Law Association. I think I know what you would say. But they have an obligation to comment and be judged.
Because they commented on lighter matters than this. When a former attorney general, when allegations were made against a former attorney general, heavy statements were being made by the Law Association that Attorney General must resign, he must go.
Yes. Well, they
Now we are
also,
seeing
they
a
also,
different treatment.
go ahead, sorry.
Yeah, now we're seeing a different treatment to this current Attorney General, and he has done far worse than just allegations because they are now proven facts and decisions damning against a sitting Attorney General. And I don't understand why Keith Rowley will harbor and continue to keep someone like this in his cabinet. He hasn't even served 1 year as yet, and this man is embroiled in so many scandals. There are more. If you go through the newspaper, just do one quick read of the newspaper, you will see the treatment of this man by the media, and it's because he has done nothing right so far. He has done absolutely nothing right. I mean, when he became the Attorney General, we all said, well, let us give him a chance. Well, I think the time has gone now for him to lose his chance. He has lost the file, he lost the appeal, and now he must lose his job.
He must lose his office. And on that point, I want to say something political. I want to say that if the People's National Movement, the government of Trinidad and Tobago under the Constitution, need only two offices, a Prime Minister and an Attorney General. And if the People's National Movement is unable, after 7 years and 2 chances, to find a single competent attorney to hold the office of Attorney General, then quite frankly, they are unfit to govern this country, and they are unfit to lead this country through the rocky waters of upholding and vindicating the rule of law.
Kyle, as you rightly said, there are two offices to occupy the cabinet, the Prime Minister and the Attorney General. And if none is working, that means the entire cabinet is not working. I think this government has lost its moral authority. The people are fed up. We are raising a lot of complex legal issues here, but the man on the ground, they're suffering. I can tell you as a member of parliament, today I was in my office for the entire day in Barataria Sawa, and people came in for all kind of things like house. They can't afford to pay their mortgage. They have no money to buy food. It is really disheartening what is taking place in Trinidad and Tobago. And then you'll see the Prime Minister, making all kind of rude, snide remarks that, well, if you don't like it here, go in Ukraine. I mean, that is not how a leader of a democratic country behaves.
No.
And this Prime Minister, as I said, he has expired on the job now. And it is about time they just dissolve the parliament and let's go back to the polls, because I think the country is totally fed up of the PNM. And I'm not speaking only for UNC supporters, but I think I'm also speaking on behalf of the PNM also. I think even the PNM is fed up of Dr. Rowley and his waste of time cabinet.
But I think it's very clear. We made the point earlier that a lot of this money we're losing because of mismanagement and poor leadership could go to to solve many social problems in our country. Some of the social assistance is certainly one way that the money could have been spent, and that all could only be chalked up to leadership. I also wanted to get on Saddam MP to the I myself didn't get a chance to study it, but there was an issue with the Firearm bill. I know that you all debated it in the House. I think it was last week, and then it was also debated in the Senate this week. What is the position? I've seen some stories on what is the position with that Firearm bill. I believe because of pressure by the UNC, one of the major controversial clauses had to be withdrawn.
Yeah. So basically, what they're trying to do is make an amendment to do several things, but the most controversial part of the bill was removing the Commissioner of Police from allowing the extension of permits, FULs, and giving that power to the Minister of National Security, who's a politician.
Yeah.
And there was no proper justification for removing the Commissioner of Police and inserting the Minister of National Security, because, as you well know, that Commissioner of Police office is somewhat insulated from the cabinet.
Yes.
And it's very dangerous to have a politician involved in extending the time or the life of someone's firearm user's license.
Yeah.
The independents and the opposition senators last evening pressured the government, and I think an amendment was being made to delete that particular clause. And I want to congratulate my colleagues, the opposition senators, for making such strong submissions and pressuring Minister Hines by removing that. So that's the first one. The second one was with respect to a matter involving I can't remember the name of the case off the top of my head, but a matter involving
Is it the
the
SSA head?
the Commissioner of Prisons being
Prisons.
able to issue FULs to prison officers while off duty. The court had ruled that that was in fact illegal because the Commissioner of Prisons did not have that power.
Yeah.
That was a measure that we had to
That was a
support because we had
Vishal, it was a Vishal
Vishal Singh, I think.
Vishal Singh, yes, that's it, yeah.
Yeah. And that particular judgment what prompted one of the amendments. And then the other controversial part of the bill was what you pointed out with the SSA, is that you're giving the director of the SSA the power to really issue a firearm to a civilian. The director of the SSA is a civilian, and the employees in the SSA's office, they are also civilian. So now you're allowing the director to be a holder of a license and also delegating him with the power to issue license to persons under his employment, under his agency.
Well, I mean,
And that is something.
it seems, I mean, yes, I have done many cases under the Firearm Act. In fact, I'm involved in a judicial review with respect to certain provisions of the Firearm Act. I don't want to say more on that, but yes, I agree the Firearm Act needs to be tweaked here and there are some things that you have to deal with. But really, I think the government's focus for the last 6 months has been completely off. They've been on a tirade and a campaign against legal firearms or firearms granted through a legal process under the Firearm Act approved by the Commissioner of Police after you are investigated by police and have to prove that you are well trained in the use of firearms. There's, to me, nothing is wrong with that process. But at the same time, you had this issue where scanners were not on ports. You have multiple or unimaginable numbers of illegal firearms in our country. And instead of bringing laws and bringing your bureaucratic and administrative prowess and focus to deal with the process of legal firearms, here we are trying to curtail and tinker, and as you are rightfully saying by some of the arguments, usurp the function of the Commissioner of Police in treating with legal firearms. The focus of this government seems to be totally off.
Yeah. And no, I have no issue at all with giving law enforcement the protection they need. The UNC has made our position very clear. We are standing with the prison officers, police officers who are in need of protection because they operate in high-risk environments.
Yes.
My issue is that why not allow private citizens also to be the holders of FULs, especially the business community? We have seen the scourge of crime. Why you can't have a system to deal with those firearm applications in a more expeditious manner? I believe the minister quoted a figure of 35,000 outstanding applications. 35,000.
Yeah.
And you have businessmen as sitting ducks in this country.
Yeah.
I mean, we call upon the government to really issue or take steps in order to expedite these applications, resource the Office of the Commissioner of Police so that she can deal with these matters in a more comprehensive and quick way. Because when a bandit enter, let me just say, we see how many supermarkets are being robbed. We see how many business places are being robbed. And these persons have nothing to defend themselves, so they have to lie on the ground, helpless, hopeless. I don't know if you remember, there was one particular robbery in the, I think in the Bucal area, where
a female business owner, not so?
Yeah, it was the holder for FUL, and she fired some shots at the bandit, and she was able to defend herself.
And her family.
Yeah, exactly. Imagine she didn't have that firearm with her. What would have been her position today? We may have been doing her yearly prayers today.
Yes. Yeah, exactly. And you're absolutely right. And the problem with that, this 35,000 applications, in the first place, some of these businessmen will institute litigation, judicial review, to force the commissioner to give them the license or to force the commissioner to file a defense, that to make a decision that will burden the state and cost taxpayers money because you have to pay legal costs and damages because of your nonsense. And secondly, why are you leaving citizens who can legally qualify for firearms, why are you leaving them exposed and vulnerable to bandits when you could give them some means? While it's not the be-all and end-all, I agree with that. I think I heard Senator Lakshmi say that yesterday. It's not the be-all and end-all. It's not the only step. I believe you said it as well, if I read correctly. that look, yes, this is a drop in the bucket, I believe was the word you used. That may be one measure, and yes, you have to look at all the other measures, but it is something, and it is a step in the right direction, at least under our laws, that businessmen's application for firearms be processed quickly and they are assessed, and if they have to get a firearm, they get it.
Correct. And going back to the point of the protective services also, giving the prison officers a firearm, but they have to go on a rent in a, let's just say, a high-risk area, you're defeating the purpose. These prison officers for years have been calling for proper housing.
Yes.
They've been calling for stab vests. They've been calling for proper alarms in the prison, for CCTV
Yes.
cameras, for the jammers to start working, the grabbers. And all of this, Kyle, boils down to a management and resource issue. Who is in charge of management and resource? The Minister of National Security. So he could try to blame the prison service all that he wants. The buck stops with them in terms of management and resourcing the prisons. And I know all of this is just a pappy show. Because when you look at the yellow books in the budget, you will see that under the heading of minor equipment purchases, this deals with the budgetary line item for purchasing of these firearms to give to the prison officers. They only allocated $500,000. That cannot at all be enough money to purchase firearms for these officers. And this government really isn't serious about protecting the prison officers. I believe last year, June or July, somewhere there, the Prison Officers Association had called for the Minister of National Security to resign, to go, because they had lost confidence in him. And there's enough reason. I don't think we could spend much more time to belabor that point. Everybody, I believe, have no confidence in Minister Fitzgerald Hines. I mean, the man is an absolute failure. He has failed in every regard, any ministry, anywhere he goes. I believe he's even a failing MP. Because when your constituents can kick water on your tail and you have to run all your constituency, that is an indictment on your performance and your representation you give to your constituents.
No, I fully agree with you, and I think who has to really take the blame for that, apart from Fitzgerald Hines himself, is the Prime Minister, because the Prime Minister has supported him. The Prime Minister refuses to move him, and at the end of the day, the buck must stop with the Prime Minister, who is the leader of his government. The buck must stop with the Prime Minister, and if it is the Prime Minister refuses to remove him, then the Prime Minister has to pay the political price when that time comes, and people must be wise enough to know that if they vote again for the Prime Minister and the PNM, that they're going to get another Fitzgerald Hines, and another Abmore, and another Alrawi.
All right. I think it's about time. I mean, the citizens really need to wake up, understand that our country is not in a very nice place. The PNM have destroyed what was beautiful Trinidad and Tobago, and I think the time has come now that we have to seek a fresh mandate. And the only people, Kyle, you know this for yourself, the only government that has properly run Trinidad and Tobago has always been a UNC government.
Yeah.
We have always stood on the side of the Constitution. We have always stood on the side of transparency, good governance, and performance. And Pandey used to say, performance beat old dog.
Any day.
For the
All
5
right,
years.
I agree with you fully. I think we're closing off there. Saddam, any closing things you want to say?
Just closing comments. I think enough has been said about this matter. I think this matter has been ventilated in the public domain with respect to that $20 million judgment. And the time has come now where the Prime Minister has to fire his Attorney General. Or, as I said before, let's call election and we're ready to go back to the polls.
Agreed. All right, thanks a lot, MP Hosein, for joining us. Have
Take
a
care.
good night.
Thank you for having me. Okay, take care.
Bakachi? Yeah. Yeah, well, I mean, we had it there from, viewers, you've had it there from MP Saddam Hosein, fighter in the parliament, obviously knows his law, his procedure. You didn't just have to hear it from me. It is clear that this disappearing file excuse has no merit, it holds no water. That should disappear as a defense, in my view. What has to happen? I think MP Parry had it nice on Monday night. He said we shouldn't be surprised that a file disappeared, Archie. He said we shouldn't be surprised that a file disappeared from the AG's office, because our comfort of living is disappearing, our energy sector is disappearing, jobs are disappearing, our quality of life is disappearing, economic growth has disappeared. So this is a government that really understands, what was their logo was vote for the PNM and the time is now and all of that nonsense. For the next election, their motto should be abracadabra. Abracadabra, hocus pocus. That should be it. That should be their next battle cry. Because we know, expecto patronum. Well, that's not misleading, man. Right? But abracadabra, that should be their battle cry. Because really, with all due respect, all they are doing is making all the good things disappear. Right? They used to have something called the minus touch. The minus touch on Sesame Street, yeah. Anything they touch disappears. Petrotrin, gone. Healthy economy, gone. Cost of good quality of life, gone. Security in our population, gone. The sense of feeling safe, gone. The sense of having a future, gone. Tertiary education, gone. Anybody else want to come on? No? Okay. But I think that is really where we are. Yeah, I don't know. Well, no. If you come wrong, you conquer that. You will be gone. Let me just tell the PNM that. If you come wrong, you conquer that. You will be gone. I guarantee that. Because I know my client and I know that the people of Trinidad and Tobago, and I believe Miss Haynes was here yesterday, Archie, and I know that she spoke about all of the ills in the education sector. All of the trouble with infrastructure, all of the trouble with not preparing students to re-enter their safe spaces. All of that, the PNM should be focusing, they're not focusing. But I leave that for Victor Roberts. You could go back and see that episode. It was an excellent interview with Victor Roberts, an excellent interview with Miss Anita Haynes yesterday, and I would commend everybody to go back and look at that if you want to understand what are the real problems in our education system. Right? So I think, Archie, I can't, I don't want to go as far as 9 o'clock. I will take it at 8:30 until your regular host, Mr. Roberts, because I didn't get to read all the newspapers and things that Anil accustomed doing. But I want to thank my brother Anil Roberts for the opportunity to host his show, douglAR Politics. I am a douglAR Politics fan. So this is a good experience. It's almost like you're getting to bat for Brian Lara. It's almost like you're getting to go on the wicket and bat with Brian Lara. I'm getting to share a space with Anil Roberts. Always happy to do that. Until when is it? What's the agenda for the week, Archie? What we have?
Well, Friday we'll be up in the Tabaquite constituency. That's facts and fiction on the road.
On the road, Tabaquite,
yeah,
right?
I think we'll be in a town called Flanagan Town.
Oh.
Flanagan Town.
Yeah. Flanagan Town, man. Yeah,
yes,
man.
Yes,
Nice area,
yes.
nice people, nice good people. And Saturday they have. I know there's a legal aid clinic on Saturday, I believe, in Mr. Rudy Indar Singh's constituency. That's what, Kuva South? North? South? That's Kuva South.
Kuva South, yes.
Right? So I know he has a legal aid clinic Saturday. I will be there. And
Anil will be back on douglAR
Anil
Politics
will be back
Saturday.
Saturday and then Sunday presser.
Yeah.
And Monday night.
Well, we ain't decide where we're going yet, but Monday night is on.
Monday night is on, yeah. I will, Friday night, I just want to say Friday and Saturday I'll be celebrating my 40th birthday, so I'm giving myself a happy birthday. and so after Friday and Saturday, if Anil calls to do the show on Saturday, he should know I said it on air. I can't make it, you gotta call somebody else, right? So until our next program, well, until you see me on douglAR Politics again, all the best, stay safe. I want everybody to keep in mind that they must not be distracted with the propaganda and the nonsense being spewed by this government on these very important issues. Their negligence, their incompetence, and their unapologetic failures have led to a disaster in one of the highest offices in our country, that being the office of the Attorney General's office. And as I said, if they are unable to competently and properly and efficiently fill the Attorney General's office, then they have no place in governing Trinidad and Tobago. Good night, viewers.